Hello, this is Sandeep Bhatia of Beaumont Law Practice Solicitors. This video is aimed at those of you who have been informed that they are at risk of redundancy. Now, the first thing to say is don't panic. You are not powerless. There are things that you can do to improve your situation. And the first thing I would suggest is that you have a game plan. What do you want to achieve? Well, what I would suggest is that you want to achieve one of two things. Firstly, you probably want to try and successfully argue that you should not be made redundant and that your job should continue. Secondly, if that is not possible, then you might want to leave the business you work for with more money than you might otherwise get and with a good reference enabling you to move on to fresh employment. So let's deal with those points step by step. So firstly, how do you challenge the fact that you should not be selected for redundancy? The first thing is to say is that your employer will either be a good employer or not such a good employer. If they're not so good, then they will take a sudden and precipitous decision to make you redundant. If that is the case, then you probably have a legal claim against your employer, but I'd need to advise you more about that, or you'd need to seek independent legal advice regarding what steps to take next. But if your employer is not so precipitous, it is likely that they will go through a procedure before they announce who is going to be made redundant. And they need to do that in order to avoid employees bringing claims at the employment tribunal for unfair dismissal. Because if there is an unfair procedure, then the recourse is the ability to take the matter to an employment tribunal. And most employers will want to avoid that occurring. So they will announce a procedure, and you should be given as much detail as possible about that procedure. And if you're not given that information, you should ask for it. So what kind of information am I talking about? You need to know, firstly, why you are at risk of redundancy. Now, if a whole business is shutting down, then everybody's in the same boat. But if it's partial redundancies and the business is going to continue, but some employees are going to be laid off, then you should be told which positions are at risk, what types of job at the business are at risk, and how many employees are at risk of redundancy. You should be told what period of time the consultation is going to take place, and you should be told that you'll be individually consulted. This applies more to firms who are making redundancies of less than 20 people. If more than 20 employees from a particular site of a business are being made redundant, then there are statutory considerations which mean that consultation regarding redundancy is more likely to take place with a union rep or an elected rep. But where less than 20 employees are being made redundant, then there should be individual consultations so that you should be able to speak to your employer about what the plans are, and you should be able to challenge those plans, because the employer should come to you at an early stage when they haven't fully formulated their plans. They should give you their ideas and they should seek your input as to how to avoid redundancies. So at some point, you will have a one-to-one meeting with your employer, and you should consider how redundancies can be avoided. For example, do you have ideas that might save your job, such as should overtime not be allowed? Should there be an across-the-board job reduction? Is there something that you can do, some kind of other position within the company where you're suited to do a particular kind of job? So think about all those arguments. Think about the business you work for. Think about challenges you can make, and make sure you fully engage in that one-to-one meeting and put forward ideas, because your employer should listen to you and should be receptive to those ideas. So if you are successful, then you should not be selected for redundancy under those circumstances. However, if you are selected for redundancy after the consultation process, that's not the end of the story, and it's not the end of all hope. Now, by law, there is no right to an appeal against being selected for redundancy. However, any good employer should give you the opportunity to appeal. And if there is an opportunity to appeal, you should appeal and put forward reasons once again why you believe that you should not have been selected for redundancy. If your employer does not have an appeal procedure, then you can think of raising a grievance or a formal written complaint regarding why you believe that you should not have been selected for redundancy. Now, if doing either of these things still means you've been selected for redundancy, then it may be the case, and this is particularly so if there's a voluntary redundancy, that your employer might offer you a package which is better than what you might get in law. Because in law, if you're being made redundant, you're entitled to statutory redundancy pay, which is quite a low level. You'd be entitled to your notice pay and you'd be entitled to your holiday pay. But your employer may try and sweeten the deal by giving you more than what you're entitled to in law. And the net result is they may require you to sign a legal document which is called a settlement agreement, in order that your employer has some kind of security against you bringing a claim at the employment tribunal against them. Here at Bowman Law Practice, I have lots of experience of advising clients regarding settlement agreements, and in some cases increasing the amount that is offered to them by the employer in return for signing the settlement agreement. Now, the nice thing about settlement agreements is that your employer has to pay, or normally pays, the solicitor of your choice to advising you regarding the consequences of signing that settlement agreement. And your chosen solicitor will also be required to sign a certificate saying they've given you that advice. And your employer would do that, because without that, if you just signed the settlement agreement and there wasn't a legal advisor certificate attached, then the settlement agreement would not be valid. So in order for your chosen solicitor or legal advisor going through the agreement with you, your employer will normally pay a contribution directly to the solicitor of your choice regarding the legal costs of going through the settlement agreement with you. What that means is that if you came to this firm with a settlement agreement, we would, under most circumstances, invoice your employer for the legal costs of advising you. And if the contribution of your employer is at a low level, we would invoice them for that amount and ask you to top up the difference. But in many cases, we manage to negotiate it so that it is not necessary to invoice you at all. So then, if matters are settled at that stage, that is the end of the story. But what if you've been selected for redundancy, you've appealed, the redundancy has gone ahead, and you are leaving under a cloud and no settlement agreement has been reached? Well, then your next step is, before you can go to an employment tribunal, is that you need to go to ACAS and you need to apply for something which is called early conciliation. This means that ACAS, which stands for Arbitration and Conciliation Service, need to be given the opportunity to try and settle the dispute between yourself and your employer. And from ACAS, a conciliator will be appointed who is the go-between between you and your employer. And they will try and negotiate or help you and your employer reach a negotiated settlement, which will be evidenced by a legal document called a COT3 if it's reached. And that would then again be the end of the matter. But if no such agreement was reached at that stage, you would receive a certificate allowing you, if you wanted, to go to the employment tribunal. And my strong advice would be to seek legal advice before you take that action of going to an employment tribunal. So anyway, if you'd like to consult with us and gain some specialist advice about your unique circumstances, then please feel free to call me. My name is Sandeep Bhatia of Beaumont Law Practice Solicitors. We're based in South Harrow. My telephone number is 0208 868 1614 or my mobile 07803 727 534. And the email address is Sundeep, SUNDEEP .Bhatia, BHATIA at Beaumont, BEAUMONDE -law.co.uk. Many thanks for listening.